I'm told that I can take this off.
In the matter of the London Steamship Owners Mutual Insurance Association Limited and the Kingdom of Spain and the French State.
Yes, you can take it off, Mr. Young, while you're speaking, and for pauses for breath in between, but when you finish your submission, it would be great.
I'm obliged, my lord. Can I start just by saying what an absolute pleasure it is to be back before your lordships in person. I'm sure it's a pleasure which you'll do your best to qualify as the hearing goes on, but it is an absolute pleasure, and I hope we are all going to return to something approaching normality soon. May it please your lordships, I appear with Mr. Jamie Hamblin, another Hamblin J, for the Kingdom of Spain. My learned friend, Miss Anna Dilnot, Queen's Counsel, I'd like to add, appears for the French state. Jointly, we appear for parties who will be described probably inconsistently as the states, and I for Spain. Sometimes I will occasionally use the term Spain for the states, but it will be a slip of the tongue. My learned friend, Mr. Hancock, Queen's Counsel, appears with Mr. Thompson for the club. I remember, I think it was over 30 years ago, being lambasted by Lord Justice Leggett for proposing a skeleton argument of 10.5 pages. Things have changed. You've now got 12 times that number of pages in the skeleton arguments, and I offer you my apologies for that. There is...
Well, that's not something we would normally permit, but there are quite a lot of points in this.
There is a whole surplus of points. I am not proposing to cover every single last dot and comma of my skeleton, or indeed my learned friend's skeleton. There will be a lot of cross-references in the skeletons, which I'm going to leave. If your lordships have a particular interest in them, then I will take them up. I propose that I will address what I regard, at least, as the principal points of dispute. But I'm more than happy to take up any points that emerge from the skeletons. Sometimes possibly with a slight hesitation, but I will do so. But I hope you'll forgive me for not religiously going through my skeleton and my learned friend's skeleton.
No, well, we have read them all, of course.
I'm much obliged for that. Therefore, you know the background, and you know that there is a raft of appeals in 3 actions, which we will refer to, or I will refer to at least, as the award claims action, the judgment claims action, and the Section 18 of the Arbitration Act application. All of the matters before your lordships relate to the issue of service. I make that point because my Lord Justice Mayles made a note in the granting of permission to appeal that an appeal under Section 18 can be brought only with the leave of the court, which means the leave of the learned judge, in this case Mr. Justice Henshaw. And he didn't give leave on the Section 18. So there is no appeal before your lordships on what I would call the substantive issues of the Section 18 application. There is an appeal in relation to the service of the application notice. And I hope in my submissions that I will be consistent in approaching it like that. There is a series of, I hope, relatively short points on what one may call the serious issue to be tried, which may have, at first blush, the look of trespassing on the Section 18, but because it's the serious issue to be tried point, it does not do so. I'm sure your lordships will pull me up if I start to argue the Section 18 point in substance. But I should tell you that following the judgment of Mr. Justice Henshaw, which was attended and argued by myself and Mr. Hamblin, Sir Peter Gross was appointed as an arbitrator, and we have had the first stage of that arbitration, the evidence stage dealing with Spanish law. The balance of the arbitration hearing is to be in January of next year. There are issues, as you will have seen, about jurisdiction, which, with a little luck, we will have your lordship's indications or in judgment, and therefore some issues before Sir Peter may or may not go away. Indeed, the entire arbitration before Sir Peter may go away, but that's another matter. So far as the Section 18 against France is concerned, the order was made by Mr. Justice Foxton in an unattended hearing, and he gave an unattended judgment. And I think under the current rules, his judgment is therefore not to be relied upon. But I understand that the arbitration involving France was before Dame Elizabeth Gloucester, may be known to at least one particular member of your lordship's court, who I think once referred to her as a stepmother brother for the LMAA. Dame Elizabeth has, I think, had the entire hearing? Yes, Miss Dilnot nods, the entire hearing, and therefore her award is awaited.
And France have participated in that hearing, have they?
My lord, yes.
Yes. Now, my lords, the award claims are claims for damages, and I use that word as covering a variety of monetary claims, based upon the assertion that the states failed to honour the declaratory awards of Mr. Schaff. And I think, I hope, following an email from my Lord Justice Mayall's clerk last week, the award and the transcript before Mr.
Well, I think we have received a supplementary bundle with that material, yes.
I'm obliged, as long as it has. I just wanted to make sure.
Yes.
We will be looking at bits of it. I think, and it was a very helpful request, if I may respectfully say so. Now, the cause of action, or causes of action against two different states, are said to be justiciable and not arbitrable. Although they are otherwise indistinguishable from the Section 18. The same is true of the judgment claims. They are claims for damages based upon the assertion that the states failed to abide by the declaratory judgments of the English courts. The judgment of Mr. Justice Hamblin, as he then was given in late 2013, and I will make a couple of points about dates. And the Court of Appeal judgment was in 2015. I pause to note that throughout that period of time, the club had not been held liable in Spain. Indeed, they'd succeeded in Spain, even though they hadn't appealed. The claims are based upon three groups of alleged breach. And I should mention this because Mr. Justice Butcher, in a ringing phrase, said, this is what the claims are all about. There are three heads of breach. One is the commencement of criminal proceedings in Spain, which had, as I will explain in a moment, a civil aspect. That's the commencement of civil proceedings, and that was in 2010, 2011. The second head of breach is continuing those proceedings as from 2011 onwards, and I'll mention in a moment how those proceedings did continue. And the third allegation is the enforcement of the Spanish judgment, the judgment of the Spanish Supreme Court as given effect to by the Provincial Court of La Coruña. Now, what brings us all together in this case is the assumption that the enforcement appeal, which my learned friend Mr. Hancock for the club is advancing, fails. That the Spanish judgment is lawfully enforceable in this country. It's quite an important consideration that the whole allegation of breach, and the reason we are here, is that the enforcement proceedings are successful, and that my learned friend's application to resist enforcement fails.
Is it when the claims we're concerned with arise if, for example, the Spanish judgment could be enforced in some other jurisdiction?
Yes, but there is absolutely no suggestion that there are any assets or any exposure anywhere else. There's no evidence that there was. Indeed, various intervals in this case, I've asked my learned friend to say whether there is an exposure anywhere else, and he has resisted the urge to identify any. So it's all, and you will see when, and I'll show you a little bit of the transcript, you'll see that that's what, before Mr. Schaff, you will see that that's what it's all about. The club, being actually a UK club rather than a Luxembourg club, the club is in England. And there is no suggestion there are any assets elsewhere. It is put forward as an entirely hypothetical point that it may have an exposure elsewhere, but without identifying any that there is. And if your lordship wants to take that particular question further, may I invite your lordship to ask Mr. Hancock what his position is on that. I rather suspect that he will say nothing, and you should therefore proceed on the basis that enforcement in England is the only issue. But the premise is that enforcement is lawful. So a lawful act is a breach of some form of obligation.
Well, that's not something we're invited to decide, is it? And indeed, the current status of that is that it's been referred to Luxembourg.
Absolutely. Well, part of it has. Yes, that's absolutely correct. But it is the premise that brings us here. And it's a premise that you really need to bear in mind, particularly when you ask yourself whether Mr. Justice Butcher was right in asking himself the question, which I say he wasn't. What is the action all about? I make the point that it is an underlying premise. I don't put it any further than that. Now, as your lordships will have seen, Mr. Justice Butcher allowed the application to set aside service in relation to the judgments claim, but not in relation to the awards claim. And we will have to examine his reasons for that difference. But at the moment, I am appealing in relation to his order in the awards claim, and my learned friend Mr. Hancock is appealing in relation to his order in the judgments claim. The reason he was against the club in the judgments claim was effectively based upon Brussels regulation, recast. And I'm not going to be addressing your lordship on those points. Somebody far more cognisant of Brussels points than I, namely Miss Dilnot, Queen's Counsel, will be doing that. And we have, as you have seen, got a consolidated skeleton. We are still going to carve up our respective handling, so with a bit of luck anyway, to minimise any repetition.
Yes, well, I'm grateful to both states for doing what I asked you to do in the order giving permission, so far as that's concerned.
I like it to be thought that we have abided by and honoured your lordship's indication. So far as the Section 18 application is concerned before Mr. Justice Henshaw, as I say, we are limited to the issue of service. And so far as any items of substance are involved, it is only in the context of serious issue to be tried. Although, as I will just mention in a moment, that creates one or two analytical difficulties in the light of the way that my learned friend Mr. Hancock is advancing his case.
Yes, well, so far as this court's jurisdiction is concerned, since the skeleton argument, since the skeleton arguments and since my order, there has been a decision of this court in Manchester City and Premier League, which you might want to look at, if you haven't already.
I might want to. I haven't already. Could your lordship give me a little indication as to what it said?
Well, it's to do with the extent to which this court has jurisdiction on an appeal under Section 67 and 68.
Yes.
The court below has not given permission. The issue in that case being whether the judgment should be made public.
Right.
Held that was not a decision under the section which this court was unable to deal with.
That's very helpful.
It was earlier this year.
Yes, I shall. It's being considered as we speak.
Very good.
Now, my lord, as I say, my learned friend Miss Dilnot and I have carved up the submissions. I will be addressing your lordships on the issue of immunity, state immunity. My learned friend Miss Dilnot will be addressing you essentially in relation to the Brussels aspects of what I'll call the jurisdiction part of the appeal. There are certain aspects of that which are discrete to Spain. They have been identified in the skeleton as being Spain only. And I will do my best to deal with those specifically. There is one point which is common to both, and that is in relation to what I'll call the declaratory effect of the award/judgment, and I will be dealing with that. But otherwise, when you see Spain only, I'm afraid I'll be dealing with that. Now, the background of the case has been very well set out and fairly set out by both Mr. Justice Butcher and Mr. Justice Henshaw. And indeed, I don't have any significant clarifications to make, although I do have, if you'll forgive me, a couple. There are 2 points of focus, if I may. and I say focus because on occasions shorthand is being used in one form or another, and I just want to put those into perspective. It is said by my learned friend, Mr. Hancock, that the claims made in Spain were claims made under, in inverted commas, the policy which is in the form of the club membership, the insurance contract. Now, that is a slightly weighted form of expression. It's important just for your lordships to have in mind. I don't think it's of central importance, but there are two claims in the Spanish proceedings, criminal proceedings, for civil damages. One was under the Civil Liability Convention, the CLC. Now, there is an argument, and I think this is why I'm telling you so that you have it in mind. There is an argument that the entire judgment of the Spanish court was also under the CLC because the club did not, and I quote, avail itself of the right to limit. Those words are in inverted commas because they are derived from Article 7.8 of the Civil Liability Convention, which says that an insurer has a direct liability, but it is entitled to avail itself of the right to limit. And the club did not appear at that stage, anyway, in the Spanish proceedings and did not avail itself. And on one view, the Spanish Supreme Court said if it doesn't turn up, it has only itself to blame. That's not really a matter for you, but I want you to have it in mind, lest any form of expression that you may engage in is inadvertently wrong. The second head of civil liability is as criminal injury compensation under Article 117 of the Spanish Penal Code. It was not made, as it were, under the club rules, but it was made because the club rules were there and because the club was sufficiently a liability underwriter for the purposes of the criminal injury compensation provisions of the Spanish penal code. So your lordships may want to keep well in mind that although the character of the claim, as described by Mr. Justice Hamblin and the Court of Appeal, the character was in substance a claim to enforce a contractual obligation derived from the contract of insurance, i.e. the claim for criminal injury compensation was not wholly independent of the contract of insurance. It wasn't actually a claim under it. Now, it may be that that is a distinction without a difference, and in which case I've made the point and you can treat it with the however you wish to do so. But it may be quite material to say that it's not actually a claim in contract, it's a claim because the contract exists. That's the first point. The second point, and if it's a merits point, it's a merits point. But I don't shy away from it. And it's this, that the club's case, to make any red-blooded English lawyer see, is that the states have no immunity because their claims in Spain are essentially commercial. And Mr. Schaff and the Court of Appeal have definitively already ruled against the states. And there's nothing, no sovereign act there. It's a commercial act. Now, if I can just, as a matter of focus only, just mention this point, that the states have each suffered an uncovenanted environmental devastation. It's uncovenanted. It didn't arise out of any commercial relationship the states had with anybody. It was the ship that happened just to spill 70,000 tons of fuel oil, which infected the beaches from Brittany to Portugal. And it was inflicted upon the sovereign territories of the states, the land of the states. And it caused considerable damage to the peoples of the states, whose livelihoods were dependent upon the littoral activities. And the states have had to put that environmental damage right. They've had to repair their own sovereign territories. And they have also had, by one means or another, to compensate the peoples of the states who have suffered from this uncovenanted environmental catastrophe.
When you say had to, you mean chose to?
They had an obligation a sovereign obligation, I would submit, to their peoples to endeavour to improve their the suffering. There is no evidence before your lordship as to whether there is an actual obligation, although in relation to my learned friend Mr. Hancock's point about subrogated claims, it arises in that context. So your lordship is right to raise it, but all I'm seeking to do is to show that the characterization of this as being commercial has another aspect. And when devastation is caused to a sovereign territory, and when vast harm is caused to the peoples who are living and working on the coasts, the state has a choice. It can pay out of taxation from its people, or it can try to reduce the burden on the national taxation by seeking recovery from those who in truth were responsible for this act. And you may, I'm sure you will be very familiar with really a very common time charter term, which says the owners have pollution cover up to $1 billion. That's referring to basically the standard form of cover that all clubs give. Well, actually, when one thinks about it, given that the position that is now being adopted by the club, that is simply a lie in charter parties, because the owners do not have $1 billion worth of cover. What they have is the entitlement to recover an indemnity for up to $1 billion if they, the owners, otherwise pay the claim. Now, I make the point simply that you have to bear in mind that this is not an unequivocal commercial activity by the Spain at all. Indeed, it is only a commercial activity by reason of a fiction, I would suggest. The reality is that the states have been doing what sovereign states do, trying to protect and enhance its sovereign territory, those peoples who are living within that sovereign territory, and to do so with the least possible burden upon the taxpayers of that sovereign territory. Now, my learned friend airily brush that aside as being motives. And Mr. Justice Henshaw agreed. In my submission, that is not properly to consider the true character of what has happened in this case. Now, when you look at the rules on immunity, obviously, we've got the 1978 States Immunity Act, and that's what you've got to apply. But my learned friend, Mr. Hancock, you will see he runs time and time again a point, which is unless the action of the state is jure imperium, then it's not, these days, he says, post Ben Carbush, it is not entitled to immunity under the Act. I would submit that that is going too far. But when you are examining the quality and the character of what the states have done and are seeking to do, you may like to keep in mind that as it were, the commercial balance is minimal, the sovereign balance is, I would suggest, somewhat greater. But I will suggest only that the term motives is not properly to give an account of what the states are doing and seeking to do. Now,
sorry to interrupt you. Can I just understand this? You talk about it being only a commercial activity by reason of a fiction. Mm-hmm. Do I understand you to mean by that the proceedings in Spain, I understand we're concerned with something removed from that, but the proceedings in Spain are a commercial transaction because they are commercial transactions.
Well, that's itself an interesting question, but yes, I'll come to that.
Because I had thought that it was common ground that the proceedings themselves
not quite.
Were a commercial transaction, but
no,
it's not.
It's common ground that was the starting point. But I'm just going to ask your lordships to look in due course at section 31C of the Estate Immunity Act, which defines commercial transaction. And I'm going to ask your lordships to consider. So maybe the word fiction is putting it a little pejoratively to my learned friend, but it's not common ground that what Spain has been doing in Spain falls within section 3.1a, or indeed 3.1b for that matter. But if I may, I'll come to that. But I've taken on board the point that your lordship has asked me about, and I will address it.
Mr. Young, what troubles me a little bit about this is that isn't everything that the state does in that capacity, albeit that it may well be property?
No, absolutely not. I mean, when you say the state does, anything that a state does, or in general, or is your lordship referring to the states in this particular case?
I didn't ask anything, so I hadn't asked any questions.
Sorry.
What I'm referring to.
What's troubling your lordship? States.
Shall I tell you, Mr. Young, shall I ask my question?
Please do.
Whether commercial activity or any other activity isn't a state, and by that I mean a state in general, is always ultimately going to be acting for sovereign purposes.
That's the motives point. The answer is, you spoke of commercial activity. We've got to look at section 3.1c quite carefully. But there are operations which states engage in which are commercial transactions. The sale of oil, the sale of gas, the building of construction of buildings. I would agree that some of them can have a sovereign component, but it's not an overriding one when the true character of the transaction entered into by the state is commercial. That it's very important that what the Act says is that it's in relation to a commercial transaction entered into by the state. Now, states do all the time enter into commercial transactions. And they will frequently agree that disputes should be referred to arbitration. And they very often, contracts say, we waive immunity, just to be absolutely sure. A lot of states do engage in commercial transactions. The question for your lordships is whether this case falls within that exception to immunity, which is a very much more specific question. But that is why when I was just describing the point, I described it as an uncovenanted environmental disaster. And it's not an unimportant word. It does not arise out of any desire for the state to engage in anything remotely commercial. So, I've made the point. I'm
interested in this. Say, for example, you have a pandemic, so the state, for all the sovereign reasons that you've indicated, needs to rapidly vaccinate its population. It therefore enters into contracts with suppliers to supply vaccines. Now, the reasons are all the sovereign reasons you refer to protect its population, etc., etc. But it's undoubtedly entering into a commercial transaction.
Yes, I couldn't agree with you more, my lord. But
I don't understand why the underlying rationale of acting as a sovereign state protecting its population and/or its territory in any way relates to the analysis of the transaction.
Then, in which case, your lordship will airily say that's all just motives. But the important thing in what your lordship has said is that the state makes transactions for the supply of vaccines. I would agree that as soon as they they enter into a transaction, that is a commercial transaction. But what happens when that is not what the situation is? As I said, states...
But the definition is rather broader in the Act.
Well, we're going to have a look at what the definition is in a moment, but I've taken on board your lordship's point, and as I said, it may be that it can be just set aside as a motive and only motive, and all I was doing was saying that may be a somewhat uncharitable response to the point. If as a result of this, various commercial transactions have been entered into with, I don't know, the suppliers of dispersant for pollution, yeah, those would be commercial transactions, I would agree. But this is not like that. But it may be that if you think it's motive, then it's irrelevant. But in the context of my learned friend's argument deriving from Ben Carbuche, which did not concern a commercial transaction at all, you should just bear in mind what we're actually talking about. And I put it no higher than that. But I'm
looking at paragraph 29 and following of your skeleton, which is under the heading of the relevant test. So I was quite encouraged by that heading.
Yeah.
And that seems to pose two possibilities. Either that the club's cause of action arises out of a commercial transaction entered into, or it arises out of the subsequent acts, namely the award and the claims. It doesn't, as far as I can see, advance any case that the pursuit of the proceedings in Spain by the states was a sovereign as distinct from commercial act. Are you making that submission?
What I say is that, well, let's have a look at the Act, if we may. I'm leaping ahead now.
But leaping, just so we know where you're leaping
I'm going to say...
Are you going to be submitting that the pursuit of the proceedings in Spain was a sovereign as distinct from commercial act?
I am going to say that the pursuit of proceedings in Spain did not fall within the words any other transaction or activity, commercial, industrial, financial, professional, or similar character, into which the state enters. And I'm going to say that a judicial proceeding does not fall within that. My learned friend will say, well, Ben Carbuche governs, and therefore it does. But all I'm going to say is that it is not obviously within those four. Well, it obviously isn't within those four defined operations, and it is not of a similar character to any of the judicial proceeding. I say no more at this stage. I will actually make the point relatively briefly. I've probably already done so, but I just at the moment I'm just making a couple of points of focus, which already seem to be rather diffuse.
But it's fair for my lord to point out, isn't it, that that's not a point you've taken in your skeleton argument.
It's
why I suggested I thought it was common ground.
Yes, no, it's. I can see why. What we say is, and I'm going to come to this, that the burden is of proving the operation of the exception is unequivocally on the club, and the club do not get that far. But can I come to this in a moment, because otherwise I'm in danger of losing my track altogether. But I've taken your lordship's point, and the point I'm making is a relatively short one.
Yes, well, speaking entirely for myself, when you do come to it, you may need to address whether it's open to you to take it at this stage without having foreshadowed it in your skeleton.
Well, yes, it's foreshadowed in the grounds of appeal. It may be not foreshadowed quite as I'm now putting it. And at the moment, I'm as I say, it's a rather, I won't say peripheral, it's an important point, but it's something that your lordships may wish to bear in mind. And if it's not in my skeleton, I still don't think there is anything in the CPR which limits one. And it probably is, and I'm wholly unaware of it, to points expressly made in one skeleton. But it's a short point, and I will come to it if I may. Now, at the moment, I'm still just dealing with background. And can I just make a couple of points about the dates? Your lordships have got a very helpful chronology in the bundle at tab 5 of the call. And I cannot but applaud the diligence of the juniors involved in the production of that. Can I just make a couple of short points? The first is that until 2016, early 2016, the club had no liability at all. And everything that the club had been doing up until then was that based upon the fact that there was, they said, a risk that the Supreme Court might overturn well, when it all started, it was before the judgment of the provincial court, that the Supreme Court might hold that the owners were liable and therefore the club was liable. So it was everything they did was prophylactic. And when the Supreme Court ruled on the cassation appeal, which cassation appeal was brought by the master and owners, note, the club not having appeared, but clearly having some part to play. It was an appeal by the owners against the relatively minor conviction of the master, which didn't enlist any civil liability. It was the offence of disobedience of an official order, but it couldn't be, that offence could not be affixed to any ultimate damage. the master appealed against that, and the Supreme Court said, no, you weren't guilty of the offence of disobedience. You were guilty of the serious offence of negligence against the environment, which was a much more serious offence. And it did carry with it the liability under Article 117 of the Penal Code for criminal injury compensation. And under the Spanish Procedural Code, liability underwriters could be liable for the damage, for damages payable by the principal criminal defendant. The conviction of the master and owners on that cassation appeal was as a result of an action taken by the public prosecutor in Spain. And there is a point to be made, at some point, that the public prosecutor is an independent arm, albeit within the Spanish state, but is not to be assimilated to the Spanish state. Now, and the public prosecutor, it was, who secured the liability holding by the Supreme Court. But until early 2016, the liability of Spain was always merely prospective. And it was with that prospect in mind that the club, rather than have its case presented to the Spanish courts, and it had a perfectly arguable case that it had no liability because of the pay-to-be-paid clause, which ironically has been successful in a number of Spanish cases, not least in the Supreme Court. What the club chose to do, while this risk was still in prospect, was to appoint Mr. Schaff to make the declarations which the club hoped would protect it from any possible prospective liability. They did not seek any injunctive relief. They didn't seek an anti-suit injunction. They didn't seek damages. They sought, as your lordships will see in the bundle which has just been provided, I think it's tab 13, the claim submissions in the arbitration before Mr. Schaff. And they sought declarations in the terms sought. This is, I think it's supplementary bundle page 272. You probably don't need to turn it up, but it's tab 13. They only sought declarations. They sought declarations of a identified in paragraph 44, not 34, which is at page 270 of the supplementary bundle, 17 internally. And they got those declarations, which they thought would be enough. Now, I will show you in due course, A, what was said in the proceedings before Mr. Schaff, and B, what Mr. Schaff actually said in his award. But it was all with an eye to a prospective liability. And that is the only remedy which they sought. And it was not, when Mr. Schaff made his award, it wasn't an award that he made which was in any way coercive. And this is a point that was raised by Lord Justice Males as to what was the formulation of the declaration made by Mr. Schaff.
Yes. Now that you've kindly supplied the awards and we've seen them more fully than we had before, I think we're minded to agree that these are declaratory awards. So you can take that point quite lightly. If Mr. Hancock wants to come back on it in due course, course, then
I'm
entirely welcome to do
I'm
so.
obliged, my lord. It saved me from wearying your lordships with quite an extensive passage in the transcripts, which. So I'm grateful for that intimation,
Well,
but
we'll see what Mr. Hancock says.
Indeed.
But we understand a bit more about what was going on.
I'm obliged. I'm very grateful for that indication, my lord. That's very helpful. So it was all prospective, and what has actually happened is that the case which the club thought it had stitched up was getting a Section 66(2) judgment, which could then be raised in enforcement proceedings under the Brussels regulation, then Brussels I, as an irreconcilable judgment under what is now Article 34, then 37, I think, or the other way around. Not that it matters. The whole purpose, as you'll see, was to get a judgment which was irreconcilable with a prospective Spanish judgment. Now, what's happened is that so far that does not seem to have had the desired effect. And one might also just notice, given that we're looking at skeleton arguments sometimes, can I ask your lordships to look at two paragraphs in my learned friend Mr. Hancock's skeleton. And it may be that in the light of my Lord Justice Mayall's indication, it's probably not quite as important as it might otherwise have been, but if I can show you. Paragraph 4 my learned friend sets out as part of the background, and he refers to the awards. One purpose of such proceeding was to obtain declarations that the club could enforce in England and ensure any contrary judgment of the Spanish courts could not be recognised in England under Regulation 44. That's Brussels. However, the club did not simply seek a shield judgment. It sought declaratory relief, and the use of such relief as a shield judgment was not the only utility of the relief sought. Now, this is one of the other purposes was obviously to resolve the dispute between the parties and to vindicate the club's rights in the expectation that the states would abide by the result in the arbitration as the correct forum for the claims on the policy and withdraw the claims that had been brought in Spain. So when one's looking at, as we will do under 3.1b, we're looking at the place where the obligation is to be performed. It's been described by the club as withdrawal of the claims in Spain. This is 3.1b. And then we go on, facing page, paragraph 8. The litigation in this case should therefore have stopped in 2015. It was, I think it's what Mr. Hancock said when he was addressing Mr. Schaff. He said it's to give the Spanish courts advice or sometimes a lesson on English law. There is no suggestion that any purpose was intended by the declaration other than the creation of an irreconcilable judgment and the withdrawal of proceedings, civil proceedings in Spain, which were all prospective at that stage.
Does it matter what the club's purpose was? I mean, suppose they didn't have this current purpose in mind then. Does that affect the question whether they can make the use of the awards now, which they're seeking to do?
No, it doesn't, but it should illuminate your lordship's view of the declaration sought. And in the light of the indication that you've given, albeit provisionally subject to Mr. Hancock, I'm just reinforcing the correctness of that indication.
I thought you were on a different point, which was where the place of performance of the...
Oh yes, I am, and I'm going to come to that. But the purpose, the notion of performance, which was contemplated, was all in Spain, or not at all.
I understand that's the point.
Yes, that's the point I'm making.
But I'm not sure that answers my lord's point. Why is the purpose in seeking the award relevant to that question?
Well, it's in identifying where there was any, in inverted commas, performance of an obligation. It assists in that, in construing the award. Once again, I can see that it may not be of central relevance, but one of the, particularly in the light of what my lord has indicated, it may be that there was no performance at all. And that may be the answer to the question. Thank you. I'm assuming because of COVID, there is no water available. Am I right? I'm getting a bit dry.
Yes, I think you have to bring your own.
Yeah, yes, I clearly my mistake. There are 2 points, just en passant, and perhaps I will deal with it very, very quickly in the light of my Lord Justice Mayall's indication. The first is that the Arbitration Act, which is in Authorities Bundle A1, tab 2. We look at our section 48, 3 and 5, which page 25 of the document at the top right. This is section 48, with which you're doubtless familiar. Unless otherwise agreed, the tribunal has the following powers. 3, the tribunal may make a declaration as to any matter to be determined in the proceedings. And then 5, the tribunal has the same powers as the court to order the party to do or refrain from doing anything, to order specific performance of a contract, and to order the rectification. So it may be that under certain circumstances there might be an order by a tribunal that a party do something and do it in the UK. What the Act does is distinguishes declaratory relief from coercive relief. And I know I'm trying to take this just as quickly as I can, given my Lord Justice Mayall's indication, and that there is a distinction which is contemplated by the draftsman of the Act between those 2 sorts of relief. And in the context of coercive relief, specific performance of the like, your lordships just might like to have in mind section 13 of the State Immunity Act, which is in tab 1 of this bundle. And I think 1 is not relevant, but 2, subject to subsections 3 and 4 below, relief shall not be given to state by way of injunction or order for specific performance or for the recovery of land or other property, and the property of the state shall not be subject. So it's really 13.2a that matters, and the qualification is in subsection 3, which is subsection 2 above, does not prevent the giving of any relief on the issue of any process with the written consent of the state concerned. So when one looks to see what is the character of the order that was made by Mr. Schaff and then by the courts, it is in the light of that prohibition on the ordering of specific or mandatory or injunctive relief against a state without the consent of the state. So when you are construing it and working out where performance was to be given, those are two background facts that your lordships should, in my respectful submission, have in mind. Now, the oddity is that given that the award and the judgment were declaratory, and the judgment had to be in precisely the same terms as the award because of the provisions of section 66(2), they were declaratory of rights. Neither the existence nor the terms of the award or the judgments was brought to the attention of the Spanish courts, who made their judgment in ignorance of that. One doesn't know why the club, having sought the declarations, it didn't at least tell the relevant court indirectly through their members that that's what the English courts and an arbitrator had decided. But they didn't. Now, there is also a point which will, I think, involve your lordships at the question of serious issue as to whether the award, which was made in the case of Spain in February 2013, in the case of France in July 2013, and then embodied in the judgment of the court, first by Mr. Justice Hamblin in October 2013, and then reinforced by the Court of Appeal in April 2015. The award had its own independent existence for, as against Spain, a matter of 8 months, and as a matter of France, a matter of 3 months. And at none of those times was there any liability held on the part of the club, nor did the club draw it to the attention of the La Coruña court, which was still considering the question. So when one is looking to the question of whether there was an obligation to abide, to honour the award, the honouring of the award was in a matter of a few months at best. Thereafter, the judgment took its place, and the judgment is what the club wanted, because they could then set up irreconcilable judgments within Brussels I. Now, the question then is what had happened to the awards upon that judgment. There is Mr. Justice Flo, with, it has to be said, the approval of all but one textbook writers, and without disapproval of any judgment, and indeed consistently with what the court had held, what Lord Justice Card held in Dalmia Cement, the cause of action in the award became merged in the judgment. It simply disappeared. This was, I'll show your lordship what Mr. Justice Flo, as he then was, in Sonatrach and Statoil. You've seen it referred to in the skeletons. And you will see that my learned friend, Mr. Hancock, says, well, that's all different. It deals very specifically with the effect of a party electing to enforce an award under section 66(2). The award ceases to have an impact. We say that's a matter of law. My learned friend says, doubtless conscious that Mr. Justice Flo is not wrong that often. He has to say, Mr. Justice Flo is wrong, but there's a serious issue to be tried. That arises in the jurisdiction case. Now, my lord, when we finally get to the question of immunity, and I'm sorry I've taken up as much time as I have, but I hope in relation to points which are of potential significance. The courts held, Mr. Justice Hamblin and the Court of Appeal held, that the states had no immunity under Section 2 of the State Immunity Act, that is, submission to the jurisdiction, because they had taken a step in the proceedings by issuing their own application under Section 67. And I will, I think, take Mr. Hancock at his word when he says that if this matter goes off to a Section 67 application, that it won't be held against me in terms of submitting to the jurisdiction then, if there's a Section 67 application. But that's a long way down the road. And I'm sure my learned friend will make clear to you that if he says it should go off to a Section 67, that should not prejudice my position with regard to submission to the jurisdiction. But that's for my learned friend to clarify, and I don't say no more. But that's because we issued our own Section 67 application. My learned friend's case now on Section 2 is that there has been a submission to the jurisdiction, not in relation to any of these three actions, but in relation to the enforcement of the Spanish judgment and my learned friend's appeal in that Spanish judgment. And he says that because we have sought to enforce and got an order from Master Cook, which is subject to my learned friend's appeal to Mr. Justice Butcher, we have submitted a counterclaim in the present three actions, or actually the judgment claim and the award claim. Now, I'll have to wait and see how my learned friend addresses that, but I would respectfully suggest I'm sorry, I've got it the wrong way around. He
says that the claim is your application to register the Spanish judgment,
that's right.
And the counterclaim are his various.
I got it. I simply, it was a slip of the tongue. I got it the wrong way around. Exactly. And several points. One is they are not actually formulated as counterclaims in any way or form. Certainly not consistently with the CPR. Neither the judgment nor the award claim. The second point is that the enforcement appeal is his appeal. I am merely resisting it. So he would have a counterclaim in his own appeal, which is, in my respectful submission, a complex notion. But most importantly, enforcement under the Brussels I regulation is supposed to be quick and simple. And if he is right, then the very fact that other proceedings have been brought outside the enforcement, but still to be treated as a counterclaim, would be totally counterintuitive to the operation of Brussels I and now Brussels Recast. That's not what a counterclaim is there to achieve. So I would respectfully submit that my learned friend's argument, whilst it succeeded before the Court of Appeal for obviously sound reasons, it is equally obviously unsound in the present actions. But I'll hear what he says, and I will say no more on Section 2.
You're not going to address Section 2 at all further?
I will if you want me to, but I was going to well, I will briefly. But at the end of my submissions. I'm anxious.
Let me raise something that's in my mind, so
yes,
you can deal with it either now or later.
Yes.
If one looks at the wording of Section 2.
Yes.
subsection 1 is what removes the immunity.
Correct.
And what we're concerned with is whether the proceedings with which we're now concerned are proceedings in respect of which there has been a submission to the jurisdiction.
Correct.
The submission being by registering the judgment. And that's the primary question. You've then got subsection 3, which provides for certain things to be deemed to be a submission.
Yes.
But it may well not be that that is conclusive as to whether there's a submission or not. One can imagine that there are things which don't involve either of those two steps, which can still be a submission.
And if I may just, I'm following your lordship, but it's 3A if it has instituted the proceedings. It's the definite article.
Yes.
Yes. Sorry.
And we're not in that territory anyway.
No.
But 3B is if it's taken a step in the proceedings.
And that's what damaged the states before Mr. Justice Hamlin in the Court of Appeal.
Yes. But so far as we're concerned, if one takes it in stages, there may be circumstances, just talking generally, may there not, in which a state may submit without either instituting the proceedings or taking a step in them. For example, if it's agreed to an exclusive jurisdiction clause in the contract, or if even before the proceedings are instituted by the other side, the solicitors write a letter saying, we're not going to take a point on jurisdiction.
I would think, yes. The first example that you gave, which is an exclusive jurisdiction clause, my experience, such as it is, of states entering into contracts which contain an exclusive jurisdiction clause, add the terms, and the state agrees to submit to the jurisdiction of the court.
Well, maybe so, but all I'm concerned to identify at the moment is what question we're asking.
Yes, I agree.
And for the purposes of subsection 1, we're asking whether there's been a submission. For the purposes of subsection 3, that will deem certain things to be a submission, but it's not exhaustive. So there can be a submission without taking a step in the proceedings. And then when we get to subsection 6, which deals with counterclaims,
Yes.
it qualifies what can be a submission in relation to certain counterclaims. If the counterclaim is based on the same legal relationship or facts as the claim, then it will be a submission. But it doesn't follow that you can't have a submission if you can't characterise something as a counterclaim. So that very long introduction is a way of raising a question in my mind, which is that the points that you've made so far all proceed on the assumption that the club can only succeed on the section 2 by starting with whether this is a counterclaim in the proceedings.
Well,
and I wonder whether that is the right starting point.
well, I now understand your lordship's point, and I'm taking it slightly out of order, but I'd much rather address the points that you make when you make them. It says, I think you've got to look, my submission is you look at what 6 says, and it's a submission is not in a counterclaim. A submission in respect of any proceedings extends to any appeal, but not to any counterclaim, unless it arises out of the same legal relationship or facts. So counterclaims...
I'm sorry to interrupt you, but your submission is this isn't a counterclaim.
It's absolutely right.
Right. So therefore, subsection 6 doesn't apply.
Correct.
What I'm putting to you is, does that necessarily answer the question as to whether there has been a submission for the purposes of subsection 1?
Well, I see the force of that. I'm addressing, when I make this point, I'm addressing the point that was made by my learned friend, Mr. Hancock. That he says it's effectively, the awards claims and the judgment claims are effectively counterclaims in the enforcement appeal, and therefore should be, they arise out of the same relationship and the same facts. I haven't, so I was specifically addressing that point. I haven't addressed the more general point that your lordship has indicated. But in my respectful submission, it brings us back to section 2.1. State is not immune as respects proceedings, and it must mean specific proceedings, a specific action in my respectful submission. If it does, then you have to ask yourself, the proceedings are, first, the awards claim. Has Spain or France submitted to the proceedings in the awards claim? No, it hasn't, or they haven't. Have they taken a step in the action? No, they haven't. Unless they qualify as counterclaims in the enforcement appeal, that's the end of the point. And the same is true of the judgment.
Well, I understand that's your case.
Yeah, no,
But we know that parties can submit in advance of the claim being made against them. That's the classic case of a claim brought. You do submit to what is properly described as a counterclaim. So you can leave aside which proceedings it's in. You can submit to the jurisdiction by bringing a claim, taking an action.
That's 3A. Yes, that's 3A. Has instituted the proceedings.
Yes, but you can, but that's just a deeming provision.
Yeah, absolutely.
You can have a submission that doesn't come within 3.1.
It's odd. It's odd, actually, that one needs that as a deeming provision, because one would have thought that instituting proceedings was the paradigm of submitting to the jurisdiction.
Yeah. Well, that may be so.
Yes.
But if we start from the premise that subsection 3 is not an exhaustive definition of what can amount to a submission, and we go back to subsection 1, then we know that you can have a submission by bringing a claim, and that's a submission in relation to certain categories of subsequent cross-claims. Not any cross-claim, there has to be a sufficient connection, so on, Lord Justice Ricks and so on. So that one's then looking, for these purposes, at what cross-claims, as it were, there is a submission in relation to.
Absolutely. Yeah.
And that's all I'm suggesting is that you're saying, well, they have to be brought in the same proceedings procedurally, is something that isn't apparent from subsection 1 itself.
I see the force of that. That's why I address the character of the enforcement proceedings under Brussels 1 and Brussels Recast as maybe, and that is effectively a proceeding which is administrative. It is intended to be quick, and it is not intended to permit the development of counterclaims.
But that's a counterclaim-based submission. You can allow the recognition to take place swiftly and without any interruption. You could say you can't bring a counterclaim in those proceedings in order to delay the recognition or enforcement. Non constat that in relation to claims brought in another way, you haven't submitted to the jurisdiction.
Well, I think when if I may, I've not, because I've been addressing in my own mind the points made by my learned friend, I haven't.
No, and that may be fair. I have to wait.
No. What I'd like to do is to reflect more deeply upon the question your lordship has raised. It is a good question, and well, in a sense, I've already addressed it. That has Spain submitted to the judgment claim or the award claim, or indeed Section 18? And the answer is no, it hasn't. So you've got to create some sort of submission. Now, the example that you've given of the exclusive jurisdiction clause is exactly that. It's an agreement to submit, so that there is an estoppel, contractual estoppel, precluding non-submission. But in a case like this, I would respectfully submit you do have to be somewhat more precise in one's application of Section 2. But I'm given that your lordship,
you understand the thought.
I've understood,
and of course you can come back to them.
I would much rather do that. I'm sure doing it on my feet would be an answer, but whether it's the answer is another matter. But And I'm sure I will have an extremely extensive and very clever note from Mr. Hamblin, which I won't understand, but I will endeavour to address that, as it were, at the stage when I was about to say, Section 2, very little to be said.
Well, I'm afraid
there is more to be said.
That's why I intervened, because
that's the virtue. That's the
it
virtue.
did appear to me that you had finished on Section 2.
No. Well, I clearly, yes. That's the virtue of the process that is involved. I'm here to help the court, and I'm here to address the points that come from the court. I will treat rather more seriously the point that your lordship has made than I obviously have done hitherto.
It could be said, I suppose, perhaps, that if subsection 3 needs to be there, that is to say, to provide that a state is deemed to have submitted if it has instituted the proceedings in respect of which the question of submission arises, it would be surprising, although not impossible, if it has submitted in respect of one set of proceedings by bringing different proceedings.
Yes. Well, that's...
So anyway, that's all part of it.
I mean, that's actually... yes, I mean, that was in a sense the point I made about Section 3A. That is, it's odd that could be so if 3A was needed. But in terms of timing, and at the moment I'm actually strange, I'm only addressing your lordships on the chronology, or they're making incidental points as they arise. The award claim action was issued before the enforcement action.
Yes.
The judgment claim action was issued after the enforcement appeal, or the enforcement proceedings. And it may be that it would be rather odd if the award claim were issued, and that's the one which has succeeded so far before Mr. Justice Butcher, if Spain submitted to the jurisdiction in that by seeking enforcement.
Yes, well, on Mr. Hancock's logic, the application to enforce the Spanish judgment might be a counterclaim in the award claim.
Except that, by that stage, the award had been embodied in the judgment. So, I mean, I'm going to come back to the analysis. I've clearly treated with less respect than it deserved the point that has now been mentioned.
All right, anyway, have we now dealt with your introductory points and what you want to say on Section 2, subject to coming back to my Lord's point? And where do we go next?
Yes. I did just want to make the point. I'm sorry, I am setting out a number of points of clarity. Would your lordship just forgive me if I... The appeal before the Court of Appeal, the Lord Justice Morbick Court of Appeal, succeeded on Section 2, succeeded on Section 9, didn't succeed on Section 3B, 3.3b, and was never addressed by the court or by the club on the basis of Section 3.1a. 3.1a has arisen for the first time before your lordships. Now, it may be that if my learned friend were right about Section 3.1a, then he could and should have brought it and mentioned it before the Court of Appeal.
Well, you may be right about that, but again, does that matter?
There's nothing in it, I agree. But it's just that when your lordships look at what, if impact, the reasoning of Mr. Justice Hamblin and the Court of Appeal have, it was only in relation to Sections 2 and 9, not in relation to Section 3. Mm-hmm. And I hope I'm not being unfair, as I apprehend my learned friend is now advancing 3.1a as possibly his best point in the light of Ben Carbouche, whatever that may achieve. But it's right that your lordship should have that in mind. Now, on the question of state immunity, which we're pleased that I finally got to after about an hour and a quarter, but I hope the points I've been making have actually set the groundwork.
I'm sure they have.
Your lordship is too kind. can I make 6 observations or propositions, which in my submission are really rather important for your lordships to have in mind. The first proposition is that my learned friend says English law has adopted the principle of restricted immunity. And he quotes the first Congreso del Partido for that proposition. And I completely accept that. The question is, what form the restricted immunity takes in English law? And in my respectful submission, it is the form of the general immunity under Section 1 of the 1978 Act, which is subject to the specific exceptions in 2 to 9. And when one comes to it, at the heart of the exceptions, they are focused upon consent of the states. Now, the purport of my learned friend Mr. Hancock's argument is that if, broadly speaking, as a result of Ben Carbuche, states have no immunity unless they were acting jure imperii, he is inviting your lordships to rewrite the State Immunity Act with its 7, 8 very carefully crafted exceptions. What he says is, in effect, that Section 1 should read, a state is not immune from the jurisdiction of the courts of the United Kingdom unless an action concerns a truly sovereign act of the state under established international law and doesn't infringe the right of a claimant to a fair trial. That's essentially his case. So that the 8 discrete exceptions are all completely irrelevant. That's his case. That really is the purport of his case, because if he's right, then there is only one sovereign immunity, and that is jure imperii, which is why I did just pause a little bit on describing what was happening in this case. Now, it deprives, the club's case deprives these specific, carefully crafted exceptions of any substantive purpose at all. And there is a point that those exceptions may overlap. I could not agree more. They plainly can. One can have, let's say, 2 and 9 can overlap. Or indeed, 2, 3 and 9 can overlap. But the fact that they may overlap is not a reason for construing one in it. It's not a reason in itself for construing one of the exceptions in a particular way, so as to avoid an overlap. But the fact that there is an overlap, whilst not being an objection to construction, may itself point to what the correct construction is. So I don't say that the fact of overlap, that you should construe these exceptions so that there is no overlap. But when there is overlap, it may assist the construction of one or other of those exceptions. And that is what the majority of the Supreme Court held in NML. You will, I don't know if you've had a look at NML. Yes, oh, that's great, thank you. Just looking, yes, I'm pleased. The Supreme Court there were considering the judgment of Mr., among other things, Mr. Justice Stanley Burnton, as he then was, in the AIC case. And he said that you should construe the exceptions to avoid overlap. They said, no, that's wrong. But it doesn't mean to say that where there is overlap, that should not illuminate the question of construction. And that is why the Supreme Court came to the conclusion that a narrow construction of Section 3 and related to in Section 3 should be preferred. And there was a majority in favour of that conclusion. So I'm not going to make any points to your lordships about avoiding overlap. I'm just going to say that taking account of the issues of overlap, there is an authoritative conclusion that relating to has a restricted meaning, which I will come back to. So you come back to the fact that there is a general immunity with 8 specific exceptions. And this brings me to my second point, which is the burden of proof. Now, in effect, what the Act does is creates a presumption of immunity, but renders it rebuttable. And on normal principles of statutory and indeed contractual construction, the burden of proving the application of an exception lies on the party asserting it. Here, that is the club. Now, I don't say that you apply anything like the contra proferentem rule, but what I do say is where there is a lack of clarity, or there is reasonable doubt, especially in the context of international law, or more precisely, customary international law, then that should be resolved against the application of the exception. Now, this is a point which arises out of my learned friend's reliance upon Ben Carbuche, and I'll let him develop that argument. But I'm just trying to make the point in advance. That Ben Carbuche acknowledged that it was not disproportionate, and thus not offensive to the Human Rights Act, for customary international law to grant an exception. And there was a debate, and you'll see from the skeletons, there is a debate as to how one ascertains what customary international law is. My learned friend's case against me, and against Phillips, must be that customary international law would deprive the states of immunity. What he can't do, however, is show that there is any such customary international law. I will show you a couple of examples of why that is absolutely not the case. There is a penumbra, a grey area of customary international law, and my learned friend needs to bring it outside customary international law, which he cannot do. Thus, as he bears the burden of proving that customary international law is against the grant of immunity in this particular case, then he fails. And I should be able then to rely, subject to all of the other sections, upon the immunity under Section 1.
thought your burden of proof point, that is to say, where there's a lack of clarity, you resolve it against the application of the exception, was, as it were, a pure point on the interpretation of the Act.
It is.
But you seem to be eliding that with a submission that where customary international law is not clear, never mind the specific language of the exceptions, then the states win.
That's sounding like this. I say that is right, that you just apply the normal question of the normal approach to statutory construction. You say Section 1 is the general rule, and then there are specific exceptions. The point that I'm addressing when I make this point is that in relation to my learned friend's reliance on Ben Carbush, which says that you cannot rely upon an exception if it infringes Article 6 of the Human Rights Act. And he says the only way you can allow a right to a fair trial, or in this case the right to a second, third and fourth bite of the cherry, is if customary international law permits it, in the light of what Lord Sumption said in Ben Carbush. And I say, in which case he needs to show that customary international law would not permit the proportionate exclusion of the right to a fair trial under Article 6. So your Lordship is absolutely right that I'm addressing principally the question of construction of the Act. Yes. The reason any question of customary international law comes into it is simply because my learned friend says Ben Carbush governs Section 3 even though it didn't purport to do so. And it's because you need to look at customary international law. So he says, so as to get rid of the immunity. I hope that's in a sense, it was a reply point that I was canvassing. But your principal point, my lord, is absolutely right. That I just say you have a general exception, a general immunity with specific exceptions. Then you have to construe them.
I think I understand your point, but wasn't that or a similar point one that was advanced and rejected by the Supreme Court in Ben Carbush itself, where Lord Sumption says at 37 and following, and particularly at 39, that the mere structure of the Act doesn't put either the immunity first or the exceptions first. It simply defines the scope of the immunity, and it's only a drafting technique that puts it in this form, which is of no significance.
Well, I say, actually, that wasn't part and parcel of the ratio of the case. But I say, I mean, given that I suppose there is just the possibility that this case may go further, I would submit that the clear wording of the Act, which was long before anybody had an idea of the Human Rights Act, well, they knew about the Convention, they didn't know about the Human Rights Act, that the wording of the Convention is quite plain. And Lord Sumption was just, if that's the effect of what he was saying, then that's just wrong. But in my submission, the burden is borne by the club, and either as a matter of construction, simple construction, or as a matter of the rather more complex analytical construction that has derived from Ben Carbush. My learned friend can't discharge the burden. The third point is on the standard of proof. Now, so far as immunities are concerned, it's the ordinary civil standard, the balance, probabilities, in the case of fact, and actually right or wrong as a matter of law. And it's the passage in J.H. Rayner. I don't know if your lordships, I'm going to try and save you from looking at too many authorities, but I don't know if your lordships have looked at what the Court of Appeal said in the J.H. Rayner case.
Speaking for myself, I haven't for the purpose
Well,
of this appeal.
Let me.
But if you give me the reference, I'll read it.
Yes, it's tab 18.
And the passage is...
And it's Lord Justice Carr at page 194 and Lord Justice Rafe Gibson at 252. And I think it's really the judgment of Lord Justice Rafe Gibson, which is most commonly...
Sorry, I missed that. Did you say 152?
One...
For Lord Justice Rafe Gibson?
252.
252, thank you.
It's in, I should say, it's tab 18. It's tab 18 in Bundle A authorities.
Bundle A, Volume 2.
Yes.
Okay. So many cases, they're not always terribly easy to find.
Yes. I have to say, there was one point at which my learned friend's argument on serious issue to be tried, you'll remember there's a point about when there's a point of law, should the court decide it, based upon various dicta in ultimo and the like. And he said, well, we can't really develop this point properly. It's a 5-day hearing before your lordships with 10 bundles of authorities and 2 perfectly competent leading counsel, and me. And if we can't do it before you, then frankly, it's not capable of ever being properly addressed. So I'm going to urge your lordships, when there is a pure point of law, which is not dependent upon any hypothetical facts, I'm going to say the correct approach is to decide it. And you'll remember, I'm going off on a tangent again, but you'll remember in Ultimo, Lord Collins said, the serious issue to be tried is there really to set up a Part 24 analogy, and I wouldn't disagree with that. But the thing is about Part 24, that when there is a pure point of law, the courts will, time and again, take the bull by the horns and decide that point of law. Obviously, if there are questions of fact which may need development or which may have an impact upon the decision of the point of law, then I would agree. But where there is a pure distilled point of law with 3 leading counsel and 10 bundles of authorities and 5 days in which to do it, then it can be argued and it should be argued and it should be decided by your lordships, not left in the air. And that's what we encouraged Mr. Justice Butcher to do, and he declined in circumstances which, at least in some respects, are questionable, I would suggest. But the point about the standard of proof is important for this reason, that there are certain aspects of the substantive disputes which are seminal to the immunity claim. And where there is such a point, you have to consider the immunity. It's not enough just to say, well, there's a serious issue to be tried, therefore there's an application of an exception. You've got to say whether the exception does or does not apply. Let me take an example. One that we've probably already strangled to death already is the issue of section 3.1b and the question of performance of an obligation. Now, my learned friend has chosen to rely upon 3.1b. That was his right. He seeks to say that the declaratory award/judgment have generated an obligation of performance in the United Kingdom. He needs to prove that on the balance of probabilities and as a matter of definitive determination of the point of law. it's not enough just to say, well, there's a good arguable case that a declaratory judgment needs to have some sort of performance somewhere and it might be in London. He's got to show that it does apply. So the standard that you apply when looking at that, the effect of the declaratory judgment and its impact upon performance for the purposes of section 3(1)(b, is not serious issue. And it's not serious issue because my learned friend has put 3(1)(b) in issue itself. He didn't need to, but he did. And it would be nonsensical if you were to decide that section 3(1)(b) is satisfied simply because there is a serious issue. It just doesn't work like that. So,
well, I see that. If we're going to, as it were, decide the case on section 3(1)(b), we've got to decide it.
yeah.
But a separate question, given that Mr. Hancock only needs to win on one of his grounds,
Yeah.
is whether if we were to be in his favour on one ground, there is any need or purpose in deciding the others.
Yes, that's the easy way out. I can see that has certain attractions.
And it has attractions for you because you will get a judgment sooner.
It has no attraction in that regard, but I can perfectly see the point that your lordship is making. But the point is, it has been argued, and it must necessarily be argued as extensively as possible for the purposes of 3(1)(b), and it should therefore be decided not on the basis of serious issue. I can put it. It would be. I was going to say an abandonment of your lordship's functions, but it would create a dichotomy of a point arises as a result of a point taken by the club, which you say, well, it's wrong as a matter of immunity if we had to decide it, but it's right as a matter of serious issue. That's just simple nonsense. So I do urge your lordships to decide what is the true impact of a declaration. And none of the points, as I've said, none of the points which have driven Altimo and driven Lord Briggs about deciding pure issues of law really has any impact at all in this particular case. But I hope that's a fair answer.
No, you've made your position very clear as to what you'd like us to do.
I do try, I don't always succeed.
You want us to answer the whole paper?
I want you to answer those points which you ought to answer according to the standard which, as a result of the way that it's argued by the club, your lordships ought to apply. I hope that's a...
I'll puzzle that one out on the transcript.
My lord, the fourth point, you may think when I set out on this trek through 6 points some time ago, but the fourth point is the importance of proving a relevant consensus, since the entire burden of the judgments claims, the awards claims, and the Section 18 are all dependent upon the establishment of relevant consensus by the states. And the obligation to honour an award is distinct from the matters which led to the award in the first place. That's quite plainly so. And indeed, I think my learned friend relies upon a decision in the top court in Hong Kong, the name of which I forget, in a case called Jarmen and Eaton Properties, where that court so decides. And I have got no problem with that. It is a different source of the obligation from that which generated the award itself. Now, the obligation to honour an award normally arises out of a contract between the parties to the arbitration agreement. And it arises usually by way of an implied term of that contract, as was held by Mr. Justice Aikins in the Bombesti case, which I think is one of the few cases actually not before your lordship, but it doesn't matter. Where there is therefore a positive agreement between the parties to arbitrate, there is then an express or an implied agreement, which by definition is not itself arbitrable. And this may therefore have an impact on the section.
Sorry, could you just say that again for my benefit?
The obligation which arises from a positive agreement between parties to a contract, express or implied, that there will be an honouring of the award, is by definition not arbitrable. Were it arbitrable, it would generate perpetual circularity. Because you would get an award, you'd get one party saying, well, you were obliged to honour it, we're going to enforce it. Oh, no, you can't do that, because it's a dispute between the parties, therefore you've got to arbitrate it. It's not. It's a different sort of obligation. It's, by definition, it's not an arbitrable one. I hope that's made it clear. Otherwise, you would just say, all right, well, okay, you go back for the arbitrator that you've got to honour the award, and then there's a dispute then about whether the next award is honoured, and then you've got to go back to arbitration again. That doesn't work. It's got to be an agreement, a consensus to abide by an award, which is itself justiciable. And that's where section 66 too, and indeed the common law action on the award, if a party seeking to rely upon an award takes that course. That's where it operates. Now, the obligation to honour an award must necessarily be founded upon the establishment of a contract to honour the award, and a contract between the two parties to the award. And it must, by definition, be one which is distinct from the arbitration agreement itself. And for present purposes, that agreement must be one which is not within the State Immunity Act exceptions. It is that agreement and no other agreement between the parties to the arbitration which led to the award which matters for present purposes. And it's that agreement which the club has to show that the states relevantly consented to. Now, as I say, the obligation to honour an award is founded upon agreement. And you, in this case, have no exposition by the club as to what is the source of the state's agreement to abide by the arbitration award. My learned friend says, speaks airily in paragraph 61(3) of his skeleton, which you can look at if you'd like to. Talks about page 19. He says, the present proceedings, this is in relation to the award claim. Present proceedings, the club brings an action on the awards at common law, suing on the obligation to honour the awards. Hold on a minute. What is the origin of the obligation? He does not say. But it can only be in contract. He's got to find a contract between the states and the club whereby the states agree to abide by the award. there is no such agreement. It has to be established, however, by the club that there is such an agreement. Now, this is, as I say, central to the identification of the critical question of discerning the relevant act of consensus by the states. And it's central to the awards claims and the judgment claims. And there is no agreement that is identified. Therefore, there can be no implied term of that agreement, a la Bombesti. Therefore, he cannot establish his cause of action because there is no obligation. Now, that is a point which is a serious issue to be tried. But he needs to establish on the balance of probabilities that the immunity is lost by virtue of that agreement.
Is this a distinct point from the fact that these are declaratory awards only, or is it all part
It's a distinct point, yes, it's a distinct point.
So there is an obligation to arbitrate, which the states are under, but no obligation to honour the resulting award.
There's an obligation to arbitrate. I'm going to come to the question of the conditional benefit principle, which may qualify what your lordship has said. And but for the moment, I'll take your lordship's point. If there's an obligation to arbitrate, you've got to find, however, an agreement to abide by the award. Now, the reason why in the Court of Appeal, before Mr. Justice Hamlin and the Court of Appeal, the case was decided as it was because Spain fell within the terms of of section 82(2) of the Arbitration Act. Should we just turn it up? I think it's A, tab 2.
Someone claiming through or under.
Sorry?
Somebody claiming
Under or
through.
through, yes. Now, but it's the bit that you haven't referred to, my lord, which is important.
Inevitably.
It's page 42 of tab 2. Or, well, top left or top right-hand corner. This is under the definitions section. And references in this part, note, in this part, to a party to an arbitration agreement include any person claiming under or through a party to the agreement. Your lordship has quite properly focused upon claiming under or through. I'm now going to ask you to look at the questions, the focus of in this part. What it is doing is saying only for the purposes of matters arising under this part, which I accept includes section 18 and section 67, of course. But it doesn't make a state, or Spain or France in these cases, a party to an arbitration agreement, generally, and it's that obligation which arises by virtue of some contract between Spain or the states and the club, which then has to be performed. But that's the problem, that my learned friend, Mr. Hancock, cannot establish an agreement by Spain or France. All he can do is to establish that for the purposes of Part 1 of the Act, not the award claim or the judgment claim, for the purposes of Part 1 of the Act, a party includes of somebody who is claiming under or through. So, and this is why it is so important to appreciate that the cause of action upon which my learned friend is suing, under both the awards claim and the judgment claim, arise out of an independently existing contract to honour or abide. Not, which is by definition not arbitrable. And that's why I said it's not arbitrable. So it's not a contract which is for the purposes of Part 1 of the Act. You don't deem a contract under Section 82.2. You deem that for certain purposes, a party claiming or through is to be within the definition of a party, but it doesn't make him a party.
But it comes back, does it not, to adapting the language of what I said before, that there is an obligation that if Spain wished to pursue its claims, it could only do so by arbitration.
No, well, I'm going to come.
But had no obligation to honour the underlying award.
Yes.
For example, as to payment of any costs.
And that relates to the Section 18, but it doesn't answer the question on the judgment claim or the award claim, because there's no distinct agreement which can justify the agreement to honour the award. I'm going to come to the question of the nature of the obligation which was undertaken by the states in a moment when I deal with the conditional benefit principle. So when I answer your Lordship's question, I'm answering it in the terms in which your Lordship has asked it. But it's very important to appreciate that the terms in which that point is inquired about is itself one that needs consideration. But I come back, if I can summarise, my learned friend, Mr. Hancock, for the purposes of the award claim and the judgment claim, needs to establish a distinct and separate obligation on the part of Spain, whereby Spain promises to abide by the award. Now, if one thinks about it, that's why one reason why I spent a little time on the chronology. At the time of the arbitration, Spain had no idea that the point was there at all. That Spain and France did not participate in the hearing, before the arbitration before Mr. Schaff. So you can't say, well, there was, even though they didn't participate and shunned Mr. Schaff, there was still an agreement to abide by the award of Mr. Schaff. You cannot construe that agreement, or you cannot create an artifice of that agreement by the use of Section 82.2. You just can't. It's analytically impossible, if my learned friend's case otherwise is right, that there is a distinct non-arbitrable obligation, or deriving from an agreement to honour. And it must be deriving from an agreement.
Can I just clear my mind? Does this have any bearing on the Section 3.1a basis of immunity? I quite understand you're addressing this by reference to whether there is a good claim or a serious issue to be tried of there being an action on the award in this case, on the grounds of whether an obligation arises at all. But is that a relevant question under 3.1a?
It is. It is. If one applies NML, it most certainly is. Because the commercial transaction, which is then sued upon, has to be the agreement by Spain to honour the award, or the agreement by France to honour the award. It would have to be. This is not, I confess, this is not easy. I've spent
the difficulty I'm having is that I had thought that for the purposes of 3.1a, one is seeking to characterise the nature of the proceedings or the claim of whatever it may be. One is not concerned with the merits.
Oh, absolutely. You're right about that.
And if, therefore, the claim is, as an action on the award, one which attracts immunity under 3.1a, So suppose that
It tracks the exception.
Sorry, attracts the exception.
Right, sorry.
So suppose for a moment that the argument were correct, which is I think one of the arguments you face, namely that A, the Spanish proceedings are commercial activity, and B, that the claim in the award claim is one which relates to that activity because that's the breach that's alleged. Never mind the source of the obligation, that's the breach. Now, if both of those are arguments are right, is there a separate question as to whether the action on the award is sound in law?
You've answered the question yourself, my lord, if I may respectfully say so, by saying it's a breach. Breach of what? Is what I say. And it's at that stage, you leap, and I'm not saying this critically, but my learned friend, when he is addressing it, leaps. Let's suppose the claim in Spain is a commercial transaction, even though it's judicial.
No, I'm sorry to interrupt you, but I'm not sure you're getting my point.
Then I'm not.
My point was that what I thought we were dealing with under 3.1a is what proceedings relate to, and whether they relate to commercial activity. Now,
yes.
Whether you look at it at the breach stage or at the source of obligation stage, I had thought one's not looking at the underlying merits. One's looking at simply at the characterisation.
Your lordship is absolutely right about that.
Right.
But I add this qualification. You say looking at it at the breach stage, and at that point you have to say, is there something which makes the conduct a breach?
Do you? Or do you simply say, is the allegation?
Because
that's what characterises the nature of the proceedings.
That's the one thing you can't say. That's the one thing that Lord Justice Rafe Gibson said in J.H. Rayner, is that it's... we might have a look at it, shall we?
Well, I had thought that the point on the Tin Council case was you've got to decide whether there's an immunity. You can't just treat that as an interlocutory decision because it arises at that stage. And just before we go there, if that is a separate concept from the concept of whether, when you're characterising what is alleged, and you do decide that what is alleged undoubtedly and definitively attracts immunity, whether for the purposes of the Act you then have to go on to a separate stage and say, and what is more, does the claim give rise to a good arguable case? Or indeed, is it right as a matter of law if it all turns on a matter of law?
I take the point that your lordship is making, but it's the connection with what is said to be a breach with the commercial transaction. Now, what I'm saying is, because you have to apply the balance of probabilities test, not serious issue to be tried, you have to say breach of what? And for that, if you're going to say that this conduct amounts to a breach, you have to say what is the origin of the term which is breached, or the obligation which is breached. That has to be decided on the balance of probabilities.
The merits do.
The merits as to whether it is a breach. And it's not good enough to say there's a serious case.
I'm not suggesting it's sufficient for a serious issue to be tried to be the question. I'm suggesting that one simply doesn't look at the merits at all for the purposes of determining immunity.
And
you look at whether it falls within the Act or not.
And I hope I'm being fair. I completely agree that. But if you're going to connect the commercial transaction with the related, if you're going to connect the two parts of the proceedings and the commercial transaction, and you say there is no commercial transaction which creates an obligation, but there is a commercial transaction which creates a breach, you have then to say breach of what obligation? It's no good to say, well, they've done something which is alleged to be a breach, if you can't identify the source of the obligation. Perhaps, can I just...
Do you? I mean, once you've decided, if you do, that the pursuit of the Spanish proceeding is a commercial transaction within the definition, I know you may want to say something about that, but assuming that that's the conclusion reached, then under section 3.1a, the only question left is whether the proceedings relate to the pursuit of the Spanish proceedings. The proceedings here relate to the pursuit of the Spanish proceedings.
Can I show you what Lord Justice Rafe Gibson said in, it's Bundle A, Volume 2. And I hope by showing you this, you'll see why I'm making the point I am. But I fully take on board the point that your lordships are making, that if you've got the commercial transaction and you've got the sufficient relation, then that's enough. I completely agree. But it's how you get the relevant relation. Now, your lordships will remember the essence of this case, and it was about whether effectively the members of the International Tin Council were liable for the debts of the International Tin Council. And there was an issue in the event, it was held by the Court of Appeal, or by the courts, that the members of the International Tin Council were not responsible for its debts. But there was a question of immunity which arose, and it's at page 252. It's the passage sidelined, and Lord Justice Rafe Gibson says at first he was taken by it, good arguable case, and then he says 3 lines above the indent, I'm persuaded that the submission made for the States by Mr. Pollock is right, because in my view the exception to immunity under Section 3 is provided. A commercial transaction entered into by the States an obligation to state which by virtue of a contract falls to be performed. It does not say allegedly entered into, or which by virtue of a contract which is alleged to fall to be performed. If a state claims immunity, then in my view the statute requires that the issue be determined before the court can try the proceedings. It was objected that Parliament cannot have intended that what in some circumstances would amount to a trial of the action before the plaintiff could be permitted to go to trial. I don't think that there is any substance in that objection. I would accept Mr. Pollock's submission that if proof of the exception to state immunity turned upon issues of fact, as in this case upon the matters dealt with by Mr. Justice Staunton, it did not, the court could give directions for the trial of those issues and so on. So that's why I say that it isn't enough, the way my Lord Justice Popplewell put it, that these breaches are alleged breaches. It's alleged breaches of what? And it's not enough to say, well, it's alleged and that's good enough.
Well, I see your point at the moment under subsection paragraph B,
yes,
that if there is, if it is relied on as an obligation of the state, then the court has got to decide whether there is an obligation of the state.
Absolutely.
I understand that. But in relation to A, if we stick with that, there is no question in this case that Spain has engaged in the activity of pursuing the Spanish proceedings.
None at all.
And therefore, the question is whether that is a commercial transaction, and if it is, whether there is
a sufficient
relationship.
Yes, and your lordship
is... And that's...
But it's not, you create the relationship. What Mr. Justice Butcher said is, you create the relationship because those were the alleged breaches. Alleged breaches, and I just say, breaches of an alleged obligation. Where is the obligation that has got to be proved? And I say that when one applies the thinking behind Lord Justice Rafe Gibson in Rayner, you have actually to answer that question. But that is the point. I think it's fair to say, if I move on, the more, if your lordships, as I'm sure you will, reflect deeply upon it, you will see that there is lurking within Mr. Justice Butcher's formulation and my learned friend Mr. Hancock's formulation, the word alleged, which is not properly addressed. But I've made the point. If upon reflection you think it's good, then great. If you think it's bad, then it's bad.
Right, that's number 4.
Number 5 is that having talked about the importance of establishing relevant consensus, which is what 4 was all about, it's the refinement of consensus derived from the doctrine of conditional benefit. And this is of particular relevance to, the 3.1b, but also particular relevance to the Section 18 application. Now, the analysis of conditional benefit lies at the heart of this case and of these appeals. The club's case is that the conditional benefit right of the states, and I emphasize the word right of the states, can and should in law be developed into a burden on the states, which sounds in a liability in damages. So there is no consensus, no actual consensus which can generate a liability in damages, but because there's a right, a liability in damages for the person possessed of that right can be generated. And if I can put it in these terms, my learned friend's argument, when distilled fully, is that the conditional benefit principle involves an unconditional liability. And in my respectful submission, that cannot be right. Now, I'm sure...
Isn't that what's being said?
It's what's effectively being said, yes.
If one applies a conditional benefit right analysis, it is essentially that the right to benefit from the claim is conditional upon arbitrating it. And arbitrating it involves both burdens as well as benefits, one of the burdens of which is an obligation to abide by the award. So what is said against you, as I understand it, is that the condition having been fulfilled, because the claim has been made to take the benefit of the right to claim in Spain, the burden has been assumed, which is part of that condition, and it is in that way that the burden by way of obligation has been undertaken, even though what was conferred originally was a conditional right. That's to say, a right which would only be converted into something which imposed burdens when the right was exercised.
The essence of my learned friend's case is that there is a breach of a right. A right which doesn't exist because he's proved it before before Mr. Schaff.
Not as I understand it. I understand it is that there's been a breach of an obligation. The obligation has arisen because at stage one there was a right, but it was a right which was conditional upon assuming burdens if it was exercised. And because the condition was fulfilled, the burdens have then been exercised, been assumed.
Can I show your lordship what Lord Gough, who knows or knew a thing too about this, said at the Padre Island?
Yes.
It's entire bundle 4 of the A bundles. And your lordships will remember that there were two, Padre Island and Defendant, which went to the House of Lords on the effect of the pay-to-be-paid clause in the context of a claim made against the club under the 1930 Rights Against Insurers Act.
I remember because I was in the case. But...
Well, do you know, it's funny you should say that. I was just looking through to see. I mean, so was I at an early stage, but I got dropped by the House of Lords.
Anyway, take me to the passage in Lord Gough's speech that you'd like us to focus on.
My lord, it has to be said that the majority judgment was given by Lord Brandon, but I think Lord Ackner agreed with Lord Gough, and there's nothing that is said by Lord Brandon which suggests that there's any doubt about it. Your lordships will remember that there were two arguments in that appeal. One was what was called the equity point, that somehow equity would require the satisfaction or the provision of a fund out of which to discharge a liability. And the other, which was Mr. Sumption's main point, I think, that's completely irrelevant at present. The other was the futility argument, that it was futile for reliance on a pay-to-be-paid clause when, by definition, the claim could never have been paid. And it's in relation to the futility point that what Lord Gough said, and that's at page 31. And at the middle of the page, it says, I turn to the point in which the Court of Appeal proved to be decisive against the clubs, which I've called the futility point. And then he summarises that point. And then between F and G, he says, I don't deny that I was, from the beginning, startled by the point, and closer acquaintance did not make me any better disposed towards it. It is, to my mind, fundamentally flawed. I start from the position that what is transferred to and vested in the third party is the member's right against the club. If there's a right, then great. If there isn't, then not. That right is, at best, a contingent right to indemnity, the right being expressed to be conditional upon the member having in fact paid the relevant claim or expense. If that condition is not fulfilled, the member has no present right to be indemnified by the club. Here, the relevant claim or expense was never paid by the member or indeed by anybody else on his behalf. That condition not having been fulfilled, the member has no present right to indemnity, and the statutory transfer of the right to a third party cannot put the third party in a better position. It is as simple as that. The fundamental flaw in the argument, as I see it, is that it assumes that the statutory transfer of a contingent right to the third party has the effect that the third party has then to pay himself. And it was that which led to the conclusion. And he quotes from Lord Justice Bingham, D. And then he says, halfway down the page, with all respect, I don't agree. What is transferred under the statute is the right. And the same is true, of course, in the present case. That right is expressed to be conditional upon the happening of a certain event. And the right, as transferred, remains so conditional. It is my opinion misleading to describe that event as a burden, since it is the language of obligation and appears to connote a duty which is transferred with the right. But there is no duty on the member to make prior payment. There is simply a contractual term that, if he does not do so, he has no right to be indemnified. The statutory transferee of the member's right is in no better position than the member. And so, if the condition is not fulfilled, he too has no right to be indemnified. Now, you'll see there that Lord Gough says, it makes very plain, there's no question of burden. If the claimant...
Well, there's no question of burden because there was a right which was conditioned and the condition simply hadn't been fulfilled.
Exactly.
Full stop.
Exactly.
But in our case, the Court of Appeal has already said the condition has been fulfilled. By bringing the claim, Spain has had to adhere to the arbitration clause by the J-Bola process of it being a conditional right. So the condition has attached.
Forgive me.
Yes.
What the Court of Appeal said was, if they wish to advance that conditional right, they could do so only through arbitration, which is a different thing.
Well, they have advanced. They have sought to exercise that right.
The condition, therefore, has failed because they've done it outside arbitration and without the pay to be paid. So the condition has simply not been satisfied. There's no obligation of a material sort. There's no burden of a material sort. There is simply an unfulfilled condition. My lord's brow is looking furrowed.
Yes. They have. I mean, I don't see why they haven't done that which brings the obligation to arbitrate into play. They have advanced a claim in Spain, which they're not allowed to do, because if they want to advance a claim at all, they have to do it in London.
And the result is, if one looks at it this way, what Mr. Schaff's declaratory award did was effectively to say there is an arbitration agreement by which Spain is bound. It is in a sense, creating the the document which embodies the agreement to arbitrate. It's not doing it in that way analytically. But until that was done, there was nothing that could be pointed to by which Spain had agreed to arbitrate anything. Now, it was a right which was unavailable unless it was enforced through arbitration, and it was after the claim had been paid, which is a very analytically different thing. It's a conditional right. It doesn't impose a burden to arbitrate. It just says, if you don't arbitrate, you don't have the right, which is not at all the same. And they didn't actually arbitrate. They didn't agree to arbitrate. It was only subsequently held in 2015 that they were deemed to have agreed to the arbitration because they were deemed parties, because they were claiming under or through a party to the relevant contract. Now, it is absolutely critical to appreciate that Lord Gough eschewed the notion of burden. And you'll see this in Mr. Justice Henshaw. His judgment says, I think the right thing to do is look at it in terms of right and burden. I say that's completely wrong. That's not what Lord Gough said at all. And if I may respectfully say so to Lord Justice Popplewell, I can understand the way that my Lord expresses it is a convenient shorthand, but it's not an analytically correct one, because there is no burden. There is simply a right which doesn't exist unless you apply by the given route. Now, the important thing is that can I take the paradigm of the contract between A and B, whereby they agree to arbitrate disputes. If you're in a trust, any dispute arising out of or in connection with. A begins proceedings on that agreement in court, apparently in breach of the arbitration agreement. But B takes a step in the proceedings. I'm sure we all remember those halcyon days when we appeared in stay applications where the whole thing focused upon whether a defendant had or had not taken a step in the proceedings. Let us suppose that the defendant doesn't raise his right to arbitration, but he takes a step in the proceedings. Thereafter, he has no right to rely upon the arbitration clause, and the case proceeds in court in the normal way. Now, nobody has suggested that as a result of that court action, if it ultimately, the claim succeeds, that the defendant can then say, but you have proceeded against me in the wrong forum, that is a breach, therefore I claim damages for that. Nobody has ever suggested that, because if it had been suggested, every time there was a case of a stay application, which is met with an argument about a step in the proceedings, it would have been completely academic, because at the end of the proceedings, the defendant would simply have an indemnity for the breach of the arbitration clause. It doesn't work like that. So what you have, if I may respectfully say...
Taking a step in the proceedings involves a waiver, the ability to insist on the right to arbitration. I mean, it's the fact that a step has been taken in the proceedings, in your example, which is critical to that.
But yes, but if it was a breach of the arbitration clause, then that would be so anyway. It would still be a breach.
Yes, but it would be a breach which had been waived or which couldn't be insisted on once the defendant had agreed to take a step in the proceedings and agreed to have it resolved not in arbitration.
Well, but for the fact that, nobody's ever analysed the step in the proceedings qualification in the 75 and the 1950 Act, or indeed now the 1996 Act, as a waiver. It is just simply it's a statutory bar. But if there is an agreement to arbitrate, which has been breached, and let us say by accident, and quite a lot of the step in the proceedings cases were almost accidental, asking for further time or the like. That was never characterised as a waiver. It was just said to be a step in the proceedings. But the breach would have been the breach nonetheless. And if you could say, the taking of the step in the proceedings was a waiver, you would have to say it was a clear and unequivocal representation that claims against the claimant, or the plaintiff as it was in those days, for breach of the arbitration clause are being waived, and there is nothing you could say. There is no way you could do that, because it would just simply not be clear and unequivocal.
Well, I'm not sure that this particular point is all that helpful. Perhaps you'd like to reflect over the adjournment on whether there is something more you'd like to say. It's seminal to, my lord, is the notion that there is a burden. And that was, I think, the term that was used by my Lord Justice Popplewell and has been used by Mr. Justice Henshaw. And that is simply wrong. And I think the only occasion, ironically, the only occasion in the passages that Mr. Justice Henshaw cites where there is any actual support for that proposition is Mr. Justice Moore Bick in the Through Transport number 2 case, where he said, there is a burden, see the Padre Island. Well, actually, that is simply wrong. It's not often. I can only say he must have been better taught by his pupil than that. But that is simply wrong. There is no burden that is relevant to this. And to talk in terms of burden when you're discussing a conditional benefit case is misleading and contrary to what Lord Gough said. Right.
I'm actually making quite good progress because I'm making incidental points as I go along, and I'm going to pull them together, I hope, in due course. I'm making
Very good.
I'm making
All right.
better progress than I look.
Good. All right, well, 2 o'clock.
Court rise. I'll now stop the live stream, so the 90-second delay